Breaking news. The Supreme Court has just delivered one of the most significant Second Amendment rulings in modern history. In a 6-3 decision, the court has set a new standard for how every single gun law in America will be judged. This is not just another case. This is the ruling that reshapes the entire legal landscape for firearms ownership, carry rights, and government regulation. To understand why this decision is so important, let's go back for a moment. For decades, the Second Amendment was treated as a neglected part of the Bill of Rights. Courts often ruled against gun owners, claiming the amendment only protected a collective right tied to militias. That changed in 2008 when the court decided District of Columbia versus Heller. In that case, the court recognized for the first time that the Second Amendment protects an individual right to possess firearms, particularly for self-defense in the home. Just 2 years later, in McDonald v. Chicago, the court made clear that this right applies not just against the federal government, but also against state and local governments. Together, Heller and McDonald laid the foundation. But in the years since, the court has been mostly silent. Lower courts filled the gap, and many upheld restrictive laws by claiming that governments had a strong public safety interest. Gun rights advocates felt frustrated. Every time a challenge was brought against strict laws in places like New York, New Jersey, or California, the courts seemed to side with the government. But now, that silence has been broken. With this new 6-3 ruling, the Supreme Court has spoken loudly. The Second Amendment is not a second-class right, and judges can no longer use balancing tests that dilute its protections. This is the beginning of a new era, an era where the Constitution itself and the nation's history guide the rules, not the shifting opinions of local officials. Let's break down what the court said, what it means for your rights, and how it will affect states across the country. Fire Part 1. The 6-3 ruling explained. The court's 6-3 decision is built around a powerful idea. The right to bear arms must be treated with the same respect as every other constitutional right. Justice Clarence Thomas, writing for the majority, explained that for too long, courts have used vague balancing tests that allowed governments to defend gun restrictions by pointing to public safety concerns. Those days are over. In his opinion, Thomas wrote that the Second Amendment's plain text, as well as the historical understanding of gun rights, must control. If a modern law restricts firearms, the government must prove that a similar restriction existed at the time of the nation's founding or in its early history. If no such tradition can be found, the law is likely unconstitutional. The 3 dissenting justices, led by Stephen Breyer, warned that this approach could tie the government's hands in addressing what they see as modern problems, including rising gun violence. Breyer argued that courts should be able to weigh public safety against individual rights. But the majority firmly rejected this reasoning. Why does this matter? Because until now, governments often won simply by presenting studies or data suggesting that restrictions might save lives. Now, that evidence is not enough. Instead, the historical record, what laws looked like in the 18th and 19th centuries, is the only valid test. This majority opinion is more than just a win for the plaintiffs in this specific case. It sets a binding precedent for every court in America. From now on, every gun law must pass the history and tradition test. This is a massive shift, and it puts thousands of laws across the country at risk of being struck down. Fire Part 2. What's changing across the states? The most immediate impact of this ruling will be felt in states with the strictest gun laws. For decades, states like New York, California, New Jersey, Maryland, Massachusetts, and Hawaii have operated under what are known as may-issue permitting systems. Under these systems, citizens could be denied a carry permit even if they met all basic requirements. Applicants often had to prove they faced an extraordinary threat, a special need beyond ordinary self-defense. In practice, this meant that ordinary citizens were often denied permits unless they were wealthy, politically connected, or had high-profile jobs. Regular Americans who simply wanted to carry a firearm for protection had no real chance. The Supreme Court has now declared that kind of system unconstitutional. This decision will ripple across the country. In New York, the state's requirement that applicants demonstrate proper cause is effectively dead. In California, discretionary approval processes used by sheriffs and local officials will face immediate legal challenges. New Jersey's strict permitting rules are now on shaky ground. Even Hawaii, known for almost never granting civilian carry permits, will have to rewrite its laws. By contrast, in shall-issue states, where officials must issue a permit if you meet clear requirements like passing a background check and training, little will change. In fact, many states have already moved toward even broader protections by adopting constitutional carry, where no permit is required at all. But make no mistake, the court's decision does not stop with permits. Other laws are now vulnerable. Magazine bans, so-called assault weapon bans, and restrictions on where people can carry may all be challenged. The court didn't strike them down today, but the framework it created will give gun rights organizations powerful tools to attack those laws in court. For millions of Americans living in restrictive states, this ruling is the beginning of a new chapter. Access to carry permits will expand, and many burdensome rules will face lawsuits that could eliminate them entirely. Fire Part 3. Text, History, and Tradition, the New Standard. At the heart of this ruling is the court's new test, text, history, and tradition. To put it simply, if the text of the Second Amendment protects a particular activity, like carrying a firearm in public, then any restriction on that activity must be consistent with the nation's history and tradition of regulation. This is a dramatic departure from the two-step approach that most lower courts used in recent years. Under that old method, judges would first ask if a law affected conduct covered by the Second Amendment. If it did, they would then apply what's called intermediate scrutiny, a balancing test where the government could argue that the law was justified by public safety. This almost always favored the government. Now, that second step is gone. There is no balancing. The only question is whether history supports the restriction. For example, if the government wants to defend a modern magazine ban, it must point to a historical tradition of banning commonly used firearms or ammunition. If it wants to justify limits on carrying in public, it must show that similar limits existed in the 18th or 19th centuries. If no such tradition exists, the law cannot stand. Critics argue that this approach locks America into the past, preventing lawmakers from addressing modern challenges. Supporters counter that the Constitution's meaning does not change based on political trends. They argue that rights must be anchored in history, not shifting public opinion. The court's majority sided with the latter view. By enshrining text, history, and tradition as the standard, the court has given gun owners and legal advocates a powerful new weapon in the courtroom. Laws that once seemed untouchable may soon fall, and judges who previously deferred to governments will have no choice but to follow the Constitution's original meaning. Part 4. How this impacts everyday carriers. So what does this all mean for the everyday gun owner, the hardworking American who simply wants the ability to protect themselves and their family? First, it means access. In restrictive states, tens of thousands of people who were previously denied permits will now be able to apply and receive them. Ordinary citizens will no longer need to show extraordinary cause. Self-defense, as the court affirmed, is reason enough. Second, it means consistency. For too long, your rights depended almost entirely on where you lived. A Texan could carry freely, while a New Yorker faced endless roadblocks. With this ruling, the gap begins to close. While states will still impose certain requirements, like background checks, training, and fees, the days of outright discretion are numbered. Third, it means more legal challenges are coming. Laws that restrict magazine capacity, ban entire categories of firearms, or create vague sensitive place zones will all be tested under the new standard. Already, lawsuits are being filed to challenge restrictions in California, New Jersey, and Illinois. Let's make this real with an example. Picture a single mother living in Los Angeles. Before this ruling, she could be denied a carry permit unless she convinced local officials that she faced an immediate threat. After this ruling, she has a clear path. She takes a class, passes a background check, and receives her permit. Now she can legally carry for her own protection, no political connections required. Or think about a veteran in New Jersey who's been trained for years but repeatedly denied a permit because local police claimed he didn't face a special risk. Under this ruling, that excuse is gone. His right is recognized. For everyday carriers, this ruling isn't abstract. It changes real lives. It expands freedom and reinforces the principle that your right to self-defense doesn't end at your front door. Fire Part 5. What comes next? This ruling may be final from the Supreme Court, But the fight is far from over. What comes next will be a long series of legal, political, and cultural battles. On the legal front, expect a wave of new lawsuits. Gun rights groups like the Firearms Policy Coalition, Gun Owners of America, and the Second Amendment Foundation are already lining up cases. They will challenge magazine bans, assault weapon bans, and restrictive training requirements. Each of these cases will now be judged under the new text, history, and tradition standard, but also expect resistance. Some states have already signaled they will try to work around the court's ruling. For example, New York quickly attempted to pass new laws defining large areas as sensitive places, including public transportation, stadiums, and even entire neighborhoods. California is exploring additional restrictions on where guns can be carried. These attempts will likely end up back in court, creating a tug-of-war that could last years. Politically, this ruling will fuel debates at the national level. Supporters will celebrate it as a long-overdue recognition of constitutional rights. Opponents will argue it makes communities less safe. Expect the issue to play a major role in upcoming elections, with candidates framing themselves as either defenders of the Second Amendment or champions of stricter regulation. Internationally, America's decision will once again stand out. Many other developed nations severely restrict or outright ban civilian firearm ownership. This ruling reinforces the uniqueness of the American approach, rights rooted in the Constitution, not granted by government permission. So what comes next? More lawsuits, more political fights, and more debate. But one thing is clear, the foundation has shifted. Gun laws in America will never be judged the same way again. Part 6. Staying informed and responsible. As we close this deep dive into the Supreme Court's landmark ruling, let's step back and consider the bigger picture. The Second Amendment is a right, but it is also a responsibility. With the ability to carry comes the duty to train, to be informed, and to exercise judgment. Rights are strongest when paired with responsibility. That means understanding the law in your state. Even with this ruling, rules about where you can carry and how you must store your firearms will vary. Ignorance is not a defense. Stay informed. It also means training. Owning or carrying a firearm for self-defense is serious business. Seek out instruction. Practice regularly. Build not only skill, but also discipline. The right to bear arms is not just about ownership, it's about readiness. Finally, it means engagement. Court rulings like this one happen because people fight for their rights in the courtroom and in the political arena. Support organizations that defend the Second Amendment. Pay attention to elections, not only for Congress and the White House, but also for local sheriffs, prosecutors, and judges. Here on Firearms Explained, our mission is simple: to keep you informed. We break down the legal decisions, the regulations, and the battles ahead, all with clarity and accuracy, so you can understand exactly how your rights are being shaped. Subscribe, stay connected, and stay responsible. Because at the end of the day, knowledge is the first line of defense, and the law is only power when you understand it. This is Firearms Explained, and this ruling is just the beginning.